Morning, ladies and gentlemen. Welcome to Magic Bricks Hangout series. Our endeavor is to trigger a buy and bring back consumer confidence in the real estate market. The topic of today's session is how good documentation can avoid legal hassles. To discuss on the same, we have Mr. Akshat Pande, partner at the Alpha Partners. Akshat completed his LLB from University of Delhi and LLM from University of East Anglia Norwich, United Kingdom. He is also a qualified company secretary. Prior to establishing Alpha Partners, Akshat has worked with law firms in UK and India. He specializes in real estate, M&A, exchange control laws, and has regularly advised clients in real estate sector, including drafting of various transactional and land-related agreements, followed by deeds and documents, advising on FDI and restructuring of existing projects. I also welcome Ijeshri Guru. She is head content and research Magic Bricks. She has been a business journalist for over 2 decades with the Times of India, the Economic Times, and the Financial Express. She forayed into research in the year of 2002. She is a regular columnist with a number of established media, including the Times of Group and others. So, without any further delay, let's quickly take up the queries now. Over to you, Jayashree.
Thank you, Pushpa. Maybe you can start with the first query. Why don't you tell us what the queries are? Welcome to the Magic Bricks Hangout series, ladies and gentlemen. We have Akshat, and Akshat is here to answer a lot of your queries. One of the reasons why we've picked up legal and we do it on a regular basis is because it constitutes a very large volume of the queries that we receive every day on our forum. Whether you are planning to buy a house, whether you already have a property, or you want to ensure that whatever you're going to buy is the titling is clear. These are all concerns that come to us constantly, and actually I thought this would be a great way to get users to find their solutions. Pushpa, why don't you take the first query?
Yes, Yashi. One of the very common queries that we keep on receiving on our forum and from our users is that what are the legal documents as a home buy we need to check before buying a property, irrespective of any city across India.
So yeah, hi everyone. I'm Akshat. As I've been in a detailed manner, I've been already introduced, so I won't waste time on that. As far as documentation is concerned, I guess it depends on where exactly are you purchasing your property from. If it is a one-to-one transaction between two individuals, then obviously documentation and the checks and balances will differ from the one which you are buying it from a institutional developer. So if it is a one-to-one transaction between two individuals, obviously you will carry out the research of the title of the seller. So that you are sure that.
Akshat, I think we are having some issues with the audio here. Can't hear you very well. Maybe you could fix that and say that again.
Is it better now? Hello?
Yeah.
Is it better now?
Yeah. You can start again. I'm sorry.
What I was saying is that the documentation would differ from case-to-case basis. If the sale is happening between two individuals, and if the sale is happening between an
Okay.
individual and an institutional developer.
Okay. I'll call you.
So I think there's some disturbance in the line, so that's why the problem with the audio. Anyways. So, in case there are two individuals buying and selling a property between each other, then the documentation will basically include the title check of the seller that his title is clear. By title, what I mean is the ownership or the leasehold rights. So, in some states like UP, you will have leasehold rights over a property and not the ownership. It is a technicality in terms of difference. Noida Authority would have the ownership, and Noida Authority would lease it on a long-term basis to the owner. And then that leasehold rights are transferred. That's why you are signing a transfer memorandum at the time of purchasing the property rather than actually doing a sale. The other things like you have to check the encumbrance over the property. So if the seller has existing loan or a mortgage over the property, then that mortgage needs either to be cleared or to be transferred to the prospective buyer, and obviously the commercials would be adjusted accordingly. In case of in case you are buying it from, sorry, I'll just complete this. So in case
Yeah.
you are buying the flat from a developer, then obviously you need to check a lot of things because the development is happening from scratch. So whether the developer has the requisite approvals, construction plans, maps, charts approved by the relevant authority, whatever is applicable to that particular jurisdiction. Plus, also then the conclusive proof of commencement of construction is the commencement certificate that the authority would have. So that certificate would basically give you an assurance that the developer has met all the necessary approvals to commence the construction, and then only he's selling. Generally, what so yeah, so this is the basic documentation that you will check before signing anything or doing any booking.
Akshat, is there a difference city to city? Because I see people asking, I'm buying in Chennai, I'm buying in Bangalore, I'm buying in Mysore, in Delhi, and so on. City to city, is there a variation in the documents that you have to check?
There's a lot of difference because property being a state subject, every state has its own documentation, and the authorities also differ. I mean, if you're buying in Noida, and if you're buying in Gurgaon, or if you're buying in Delhi, all the three are lying in different states, and all the three have different authorities for granting necessary approvals to the developers. So obviously it will vary to a significant extent from a state to state and from a city to city as well.
Wonderful. So what we will do is, I'm assuring our users that we will actually sit with Akshat and maybe evolve a set of documents for different cities basis the queries that we've received, and we'll upload it as part of his answers so that even post this discussion, you will be able to look at the list of documents and figure out what you should be looking at, right? Let's go on to another question. There's Akanshi from Noida who says, what background check is essential while shortlisting a good realty expert, especially in legal? It's very important that you know how to choose your expert.
So by realty expert, you mean the developer from whom you are purchasing the flat, right?
It could be a developer, it could be the agent who's going to take you through the transaction, it could be the legal entity that you're going to who will advise you.
So as far as the developer is concerned, I think once you zero down on the area where you are buying and the which property you are buying, the best way to check the veracity of the developer is to either you go to their office and ask for all the documentation which is required. Usually they are not very entertaining in sharing the documents. That's what has been the experience of most of the people, including mine, when I was purchasing my flat. The easiest way is exercise your RTI right. You file, if you have time and if you're not in a hurry, you file an RTI with the relevant authority and ask for a particular development. So if you are suppose buying in one of the construction projects in sector, I don't know, 120 of Noida, you identify that project and you name that project in the RTI application and say that please give me the copies of all the approvals required for construction of this particular project, which apparently is being done by so and so company. You please provide me because sometimes what happens is, although there is a larger developer on top, they are doing it through some subsidiary companies or SPVs or in a joint venture with somebody else. So you don't know exactly which is the developer who will be signing the agreement. So you can ask all these details from an RTI application, which is extremely helpful and easier to get. And so, yeah, these are the main sources. Apart from that, you can have your lawyer or chartered accountant or company secretary, whosoever you want to engage, to do a background check on the financial capacity of the company, so that whether they will be able to pull off the project or not. So all these
See,
things.
Akshat, when you buy a property, it may very well be the first legal transaction big legal transaction that you're doing. And how do you go about searching for a good legal advisor for yourself? What are the things that you have to keep in mind?
Uh, so legal advisor, I mean, basically it depends on I mean, I think the biggest consideration would be cost of the professional. So you will have to, I mean, either through personal references or through looking at websites, because there is no sure source where you can see rankings of lawyers, and sadly there is no Practo kind of a website right now for
Right.
lawyers. So
Right.
probably this is a good business idea for some entrepreneur who's working on lawyers to actually rank lawyers in a particular area.
Right.
So far as that is, and best is to go by word of mouth and ask your friends and colleagues and family and see if you can find out some good professional, and then
Yeah.
you do a little bit of background check on their LinkedIn profiles or something like that. So that's
Okay.
pretty much you can do. Yeah. What
Okay.
comes to us?
Let me go to a different kind of question. There is
Yes.
Arvind Pande who says, I bought a property and got it registered on my name in Indirapuram in 2013, but I
Mhm.
haven't got mutation done. Is it necessary? And what could be GDA's charges?
What would be, sorry, what was the second part?
The Ghaziabad Development Authority's charges.
Charges. So charges, I don't remember on
Yeah.
top of my mind right now, because and you can easily get it on the
I'm
development
sure you can get
authority.
it on the website, right?
Yeah, easily you can get it.
Yeah.
But as far as mutation is concerned, yes, mutation is required, because basically mutation is a revenue record where the properties details, sorry, the ownership details are recorded, so that it can be ascertained who is responsible for making the payment of the municipal taxes and charges. So mutation record is a good resource to check the title of a particular property also, if you are going to check. In case if you don't get it mutated immediately after taking over the possession and registry of your property, then I mean, if then you are planning to sell it later on, then obviously it will become a problem. So it's better to get it mutated as much as early as possible.
And mutation is a mandatory process in every authority.
Yes, mostly it is. Yeah.
Okay.
Yes.
So if you buy a property, listeners, make sure that you also get the mutation done that transfers all property documentation into your name, so that later when you have water, power issues, when you want to sell your property, it will all be documented in your name and not in previous owner's name. Right, Akshat?
Correct. Correct.
That's right. Okay. We have a query from John of Bengaluru who says, to buy a flat in Delhi, what are the documents one must check? Please advise. Maybe we can take this query and then tell other users. If you are looking at property documentation, we will get advice from Akshat and put it up on the website very shortly.
Sure.
But this one you may want to take.
So, as far as Delhi is concerned, if you are buying it from, say, Delhi Development Authority in an auction or something, or even if you are buying a DDA flat in a second sale or a third sale from an individual buyer, the documentation is pretty minimalistic, because you just have to check the title of the seller, and you don't have to go too much in history, because DDA, you can safely assume that DDA must have taken it legally and stuff like that. However, if you are buying it as an individual house, then obviously the check would be required. So you'll have to go to the local sub-registrar's office and do a due diligence of the title of the property, like I said earlier. You'll have to check whether there are any encumbrances, registered mortgages in the name of the property. You will also have to check if there is some land acquisition issue or something like that recorded in the sub-registrar or the mutation records. So this is, I mean, basically you will have to run a due diligence on the property. Other than that, once the title is clear and you are okay with the title, your lawyer gives a certificate of to that effect, then you will have to go ahead and register your sale deed. So get your sale deed drafted, and go and basically present yourself for registration. For registration purposes, broadly, these days Aadhaar card is mandatory in Delhi. So you will have to get an Aadhaar card. If you don't have an Aadhaar card, then you will have to apply for one and show the application number there in the registrar, so that you can register the property.
So this is actually a very important issue. If you have a property, the government of India is trying to link all the properties that you own to your Aadhaar card, so that if you own a property, the Aadhaar is the one point of contact for anyone to know whether that property is indeed yours or not. And therefore, it is
Correct.
important that you link your property transactions to your Aadhaar card. It is mandatory in all state governments, right, and all ULBs.
Not in all states. So far, what I understand is that it is basically in metros, Delhi being one, because we work extensively in Delhi, so I know about Delhi. Actually, I mean, in the recent litigation related to the Aadhaar card, the linking of Aadhaar to everything by government authorities has also been challenged
Right.
because of privacy issues and etc. So obviously, the state government have not implemented that so far, and we still are waiting for the final judgment as to whether we should do it or not do it. So let's see. But in Delhi, so far as right now, it is.
It is recommendatory, but it is good to do, right?
Yeah, obviously.
Okay. We have a large number of queries about the agreement of sale. Could you tell us what is this agreement to sell and how it is so important when you're buying a secondary property or buying it from the developer?
So, very simply put, agreement to sell is basically what it says. It is an agreement to sell the property in future. It is not the sale deed, the definitive sale deed as of now. So, if suppose you want to purchase a property, if I want to purchase a property and say I want to say apply a loan, so I need say 30 days time for taking over the property. So I would do an agreement to sell. I will give a token amount or an advance or a honest money or whatever you call it, and I will do an agreement to sell. By doing an agreement to sell, you basically record your rights to purchase the property in future, and you have a right to purchase in case the seller backs out, or if he increases the price later, you can take him to court. This is on that. But it doesn't transfer any rights or title in the property as such, so far as agreement to sell is concerned.
It's like an intent document, right?
It's like an intent document, but slightly stronger than an intent document in the sense that it gives the purchaser right to seek specific performance. So what it basically means is that in case the person backs out, I can go to the court and seek a decree of specific performance saying that I want to purchase this property and you will have to sell it to me at so much price.
Okay.
So, so that is basically a kind of a stronger document than a letter of intent or an MOU.
And what are the elements that are documented in the agreement to sell?
Agreement to sell is the intention of the parties to buy and sell the property at a future date, which is a definitive date like 1 month, 3 months, 6 months down the line.
The details of the property are given in that?
Details of the property, the whatever, if there are any conditions to be met before actual sale happens, so those conditions are also listed out. Like for example, you have to take some approvals, or you have to redecorate the place, or whatever it is. Then the consideration is recorded. So the amount that is payable. So if you're taking say 20 lakh rupees worth of property, so you will say that I'm ready to pay 20 lakh rupees, out of which I am paying an advance of say 5 lakh rupees under this. So that part, the consideration amount is recorded. And then there are certain representations and warranties and covenants related to the property which the seller is passing on to the buyer, based on which he is agreeing to buy. So this
And is this executed on a stamp paper or something?
Yes. So stamp duty in most of the states, the stamp duty would be a nominal stamp duty of 100 rupees or 500 rupees. However, in some states, agreement to sell is also so there are three things that you can do with an agreement to sell. Either you want to sign it on a nominal stamp duty. In case the possession also, it slightly gets technical here. So in case the possession of the property is being given under an agreement to sell, but the sale deed will happen later, then you will have to compulsorily register the agreement to sell also,
Okay.
as per the Registration Act. And the third thing is that optionally you can pay the full stamp duty at the time of agreement to sell, and then there will be no stamp duty at the time of sale deed. So basically, you are securing your right to register the property at present right now. And although it is not compulsorily registerable, but you are securing your right to do so.
Okay.
So,
And you're paying a token amount for this.
and you're paying a token amount. So you want to, in case you want to really secure the property, yes, I do want it, and you are highly suspicious about the seller, then you want to pay the full stamp duty, get the agreement to sell it.
Okay. That was extremely useful information, and users, we will highlight this in our further write-ups, and we will definitely get Akshat to answer more queries if you have it on our forum. We've got Anchal Gupta who says, "Can you please help what I can do if I want to buy a DDA flat, but there is no registry paper, only power of attorney is available. The registry has been lost by DDA. What can be done in this way? Please help."
Wow. So obviously it is an extremely fact-based question. So assuming that these are the only facts, so what you can do is see. So buying earlier there was a trend that people used to sign a power of attorney, and they used to transfer the property under a power of attorney, in which the attorney or the person who is getting the power of attorney had the power to resale the property. So it was basically a illegal way to save the stamp duty. So there was a Supreme Court judgment and various judgments after that, which basically held that this way of transferring the property under the power of attorney is illegal, and one should not do it. So after that, all the states have amended their stamp acts. Stamp duty being a state subject, all the states have amended it, saying that even on a power of attorney, if you are doing, the same stamp duty will apply. So basically, the advantage has been nullified now. So if this particular case, the property was transferred by way of a power of attorney, then obviously you should avoid doing it unless and until you can actually get hold of a certified true copy of the sale deed or something from BDA, the sub registrar office. In case the original sale deed has been lost, then obviously it is a problem. In case it is still not it's not available at the sub registrar office or at the DD office, you will have to find it out. I think it should be avoided because then it is obviously a problem.
And actually, there is a process where you will have to, the original owner of the property will have to file an FIR because it is a legal document that it is
So
lost, and then
correct.
register
So
it
if
with
the sale
the
deed,
DDA,
if the
right?
sale deed has been lost by either the authority or by the seller, then you will have to file an FIR and get the. If the authority also doesn't have a copy, then what the authority can simply do is to give a certificate that yes, as per our records, so and so person is the owner of the property and the sale deed has been lost, and you will have to make your peace with that. So that is
Okay.
the only thing that you can do.
Okay, let's go on to the next question. We've got Pariksha Chaudhary who says, "How can I get a way out of a property I want to sell is occupied by tenants? They do not want to move out. I have power of attorney in my name. Can I sell my property without their consent?"
So obviously, this is a case of illegal acquisition of the property, and there are both civil and criminal actions that you can take against the tenants. Criminal action being more effective for obvious reasons. So I would suggest that you immediately do that, and I think barring, I mean, unless and until the tenants are really, a problem or are of a criminal nature or something, then I think it is pretty easy to get it that way.
Oh, okay. Till now we've been addressing the concerns of a buyer. Now we've got a seller who says, she's
Hmm.
Radhika from Gurgaon, who says that as a seller of a 2 BHK unit, how can I be sure that the party buying my apartment pays me in the preset time?
Okay, so it boils down to the agreement that you do. So you will obviously have to um, take assurances in the agreement. And then, in case you are still not sure about the financial capacity of the party, then you will have to secure it by either taking some kind of bank guarantee or uh, some kind of another security or something which you can actually secure in your favor, or some alternate properties documents you can keep as a mortgage with you. So your various things you can do to secure your position so that the purchaser has to pay in a definite time. Um, um, and in case they are going to take a loan or something, then you will have to make sure that bank is liaising directly with you for making payment of the loan. So yeah, various things you can do.
Okay. We've got three or four queries on people who have ancestral property. Let me go through two, three of them, and then you could probably answer the ancestral property part of it together. We've got Alok from Bihar who says, my sister and I have inherited my grandmother's house. Since we are clueless about the documentation and no one seems to know about it, how can we move ahead with creating a will, etc.? The second one is we've got Vijay from Gurgaon who says, how to get ancestral property transferred to own name if there are no documents available. This is a problem with a very large number of people where the documentation has been faulty or they don't have the documentation. The people whom they've inherited from probably have kept it somewhere and they're not aware of it. How do they execute their deeds?
So, see, ancestral property, when we talk about ancestral property, the religion-based laws becomes very important. So, either we are talking about Hindu laws or Muslim laws, or and depending on those laws, we'll have to see exactly what is the testamentary requirements in that. So in case there is no will, or in case there is no, generally what will happen is that you go to a local court and you will ask for what is called a probate, and you will have to get the probate release from the court, in which the court basically follows the procedure and asks public at large as to whether they will have any objection if so and so are declared as the legal heirs and they will inherit the property. In case is there any objection filed, then those objections have to be removed, etc. And then you will have to get it in your name registered in your name. So, in absence of a will, this is the procedure you will do. In presence of a will, where there is a dispute as to whether the will is right or wrong, or whether if there are two competing wills present of a particular person, you will have to again go to the court and prove the will which is correct. And according to that will only it will be done. So, I mean, these are the basic procedures that one has to.
For property where you do need a succession certificate when you have to prove that you are indeed the owners, right? The inheritors.
Correct.
So these are some of the things that you have to keep in mind. If one loved one passes away or and you inherit the property, you have to actually prove to the court that you are the successors and you have the right to inherit the property.
Right.
Right. Okay. We've talked about buyers. We've talked about sellers. We've got somebody who's a lessee, and says that Shakti Arora from Meerut says, "What problems will I face as a tenant if I don't make the rent agreement? What are the advantages to having one?"
Well, as a tenant, you have to do a rent agreement. You cannot say that rent agreement is an option, because both from a landlord's point of view and a tenant point of view. Because if you're a tenant and you don't have a rent agreement, you can be kicked out anytime. If you are landlord and if you don't have a rent agreement, your property is gone. So both ways, the rent agreement is obviously required, because that's the only thing that defines the relationship between the two parties.
Right. We've got one query from a seller who says, "What are the documents I must have in place so that I can sell easily?" Actually, we find Akshat that right now the number of sellers in the market are very large because people want to sell and upgrade because the markets have been flat and they can probably upgrade their old properties to a newer one, or they can actually think of a bigger unit because they have more purchasing power. But what are the documents that you must have in your possession so that you can make an easy sale?
So, briefly put, if you already have done the sale deed for, so basically I think the number of questions number of people asking these questions would be more in the sense that they will be an allottee of a property,
Sure.
and they want to transfer the allotment rather than actually transferring the property, because the property is still not in existence. Because most of the developers have defaulted in giving the possession in time. So so basically what it means is that they are transferring their allotment to a particular person, and that person will basically come in their shoes as an allottee of that property. So for that, you obviously need your allotment agreement in case you have signed one with the developer. I have personally seen a lot of cases where the allottees have not even signed an allotment agreement, and they are just getting letters from the developer for making further payments or etc. So that becomes extremely difficult and a tedious process because allotment agreement is not there. So you don't even know the terms of allotment, and you don't even know the terms on which you can transfer the allotment. So when you are transferring, you don't even know where you are standing. So first you need an allotment agreement signed by both the developer and yourself. Then you would need all the receipts and correspondences between yourself and the developer, so that the prospective buyer knows as to what is due and what is not due. Because he will obviously ask you to sign on an agreement which will say that you have paid everything and nothing further is due. So you have to make sure about that. Otherwise, there is an indemnity claim that you have to do this. Then third is obviously your normal documentation of your address proof, PAN card, etc., income tax status. And there are certain additional documents which become important if you are an NRI. So there are certain compliances which you have to do under the foreign exchange management act to an NRI if they are purchasing a property.
Are there any NOCs you have to obtain, or are those after you've decided to sell?
So the NOC is basically when you are transferring the allotment. The only NOC that you will require is from the developer, because the developer is only expecting payment. So so the transfer of allotment is a tripartite endorsement that you would do between transferor, transferee, and the developer. So if the developer is signing on the transfer endorsement, then basically he's saying that nothing is due and you can transfer. So that itself forms for better documentation and for all for a better transfer, so that the transferee gets an assurance. You can take an NOC from the developer. If it's already a registered property, and if it's already an existing property, then obviously you require a lot of other things like electricity bills and water bills and municipal charges and the NOCs you require from the buyer or seller.
Okay. Thank you so much, Akshat, for joining us. The queries are continuing to pour in, but unfortunately, we have 2 minutes over our time. But we assure our users that if you send in your queries, we will get it answered and put it back on the forum. Over to you, Pushpa.
I'm really thankful to our guest speaker, Mr. Akshat Pande, for participating in this Hangout session. It was indeed a great and very insightful session. I would also like to thank all the participants for their support in making this Hangout session a great success. Thank you all. Thank you, Jayashree, and thank you, Akshat.
Thank you. Have a great day.